we know that Kathy Durst seemed to just vanish without a trace. And Robert Durst's testimony is that he took her to the train stop and saw her leave and just didn't think much of it at the time, then realized that when he wasn't hearing from her, something had gone terribly wrong. Her body never found, no one ever charged with her death. However, she has been declared legally dead. I'm curious where John Lewin is going with this. Let me bring in, for some analysis, criminal defense attorney Lara Yeretsian, who practices in California, same jurisdiction where this trial is happening in Los Angeles. Lara, what do you think about this? Do you think, are we getting to something like maybe money motivation? I know what I kept thinking was, ooh, we know there's talk of divorce. A divorce hasn't gone through. But if somebody is cheating, sometimes states have laws where if there is a cheating spouse, the other spouse who was cheated on could be receiving lots of money in the event of a divorce. What do you think here?
I mean, it's possible that that is where he's going. It's also possible that he's just establishing motive as far as why Durst may have killed his wife. I mean, he kept on asking questions about how Farrow was not willing to continue this relationship with him as long as he was with Kathy and he was married to Kathy. And he did ask the question of what resolved this, and it was the disappearance, obviously. So I think he's going down the road of establishing motive here.
Right, absolutely. Absolutely motive. You know, how I'm not quite sure yet. It was like just as it was starting to get juicy, because who knew that Prudence Farrow, this woman he had this affair with, talked to authorities. So John Lewin definitely has something up his sleeve. And then here you saw that objection to hearsay. I mean, they had a good basis. Defense team was absolutely right to stand up and object to what Prudence said, because Durst couldn't remember here. It was a very clumsy way of, in my opinion, of John Lewin saying, well, we'll talk at sidebar and then I'll explain why I'm going to impeach him. Well, no, you got to get him to commit to the testimony, right? And then confront him with the inconsistency. That's how it goes under the rules of evidence. This case has been really sloppy. Your thoughts on that, please, Lara?
Well, it's an interesting one to watch. It's very unconventional style, obviously, by Mr. Lewin. I mean, every prosecutor and every attorney, they've got their own style, and certain things may work for one, not others. But again, it's not necessarily the typical way that it's done. He's just taking way too long. At times, it's extremely difficult to follow. He's going to lose the jury at some point. It's very difficult for anyone to sit through this kind of testimony. I mean, I'm surprised Durst is not exhausted yet. I mean, he's pretty bright and intelligent. He really thinks through all the questions and answers that he gives, and that bullying continues even when he stops to try and remember things that are from 39 years ago. So, I mean, it's an interesting dynamic. But again, he could have been a lot more effective doing it a different way. But again, I mean, who are we to judge?
That's right. Well, you know, and in these roles that we're in today, that's what we do, the legal analysis and call balls and strikes, just speaking honestly here. Let's take a look at a clip, and then I'll get your assessment of it on the other side, Lara. This is where John Lewin is confronting Durst on cross, accusing him of committing all 3 homicides. Okay, Lara, you are licensed to practice law in the state of California. So let me ask you this first, please. With hypotheticals, has it been your experience ever in a case that you may ask hypotheticals to someone who is a lay witness, not an expert witness?
Usually, hypotheticals are asked, in my experience, to experts, because once evidence comes into the trial and certain facts are established, based on those facts, we create a hypothetical and try to ask questions from different angles. Usually, I use it with experts. I haven't used it personally with lay witnesses.
And that is because you use the rules correctly, Lara. That's exactly what they're designed for, right? Because experts are experts. They can answer hypotheticals under the law. So, of course, you would do it appropriately. Here, I'm surprised that there wasn't an objection at the outset to John Lewin even giving Robert Durst a hypothetical. But like you said so well, this case is unconventional. Lara Yeretsian, so great we have you here. We're going to step aside for a quick break because they are still at that sidebar. We'll get you back into the courtroom after this. This looks to me more like an interview, almost like a police detective interview. We know John Lewin's done some of that with Robert Durst in this case when he was arrested back in 2015 and charged. What do you think watching this cross, please?
It really is not the typical. I mean, even John Lewin himself technically is a witness because if
Right.
he's done that interview, at one point I was watching this a few days ago, and he was talking about, you said this to me, and didn't you say this, and didn't I say this, and it was a back and forth. I'm thinking, you shouldn't be doing this cross. Someone else should be doing the cross because technically you had a conversation with him, and you're asking him about what you said and what he said. It's just the most convoluted thing. Listen, sometimes he's effective. But even when he calls out the evasiveness of the witness and some of the issues and the inconsistencies in the testimony, he's also coming across as a bully. And that in itself, I don't think is very effective. And no jury likes a prosecutor who comes across as a bully. Now, and I mean, I can see some of the tactics. What was really strange to me was also what he said, that and the judge was telling him, giving him advice basically, saying start
Right.
leading the witness, because that is the most effective way to get the witness to give you the story that you want him to give you. You literally put the words in his mouth, you put your theory in his mouth, and he either agrees or disagrees. And I mean, at least I find it the most effective way of doing it as a defense counsel.
Yes.
Basically, that's all we do. As defense counsel, all we do is pretty much in a trial is cross-examine. Sometimes we will have our own witnesses and we'll do some direct examination, but probably 80 to 90% of what we do is cross. And that is the best way to cross, is by leading.
Absolutely. 100%, no doubt about it. It is dangerous to do what he's doing. It is dangerous not to lead a witness. And you don't learn new information on a cross. No, you're the star when you're the lawyer. This is just something else. This trial's like nothing I've ever seen. Lara Yeretsian, I'm so glad you're on the program today to help us break it all down.